The following video was recorded on stolen Aboriginal land. CEDA acknowledges the first people of the land on which we live and work and pay our respects to elders past and present and emerging.
Now just before we officially go to content, just go around the room and just ask what brings you along to you today. Shall we start with you, Billy?
The reason that I'm here today is because I was invited. Someone asked me to participate in this, and I'm also a board member of CEDA, so I'm interested to see this event, and I wanted to support you, Joseph, while you're presenting today.
Thanks, Billy.
Also, sometimes, it's something to bear in mind, some tips and tricks that I can keep in mind for the future, and obviously it'll benefit everybody else in attendance today as well.
What about you, Sean?
Yeah, so I run my own business, Social Model. It's an NDIS provider assisting young people with the transition from school and into work. So yeah, pretty pertinent. And I've seen Joseph speak a couple of times and he's brilliant, so I thought I'd better come along.
It's Justin, isn't it?
Jake.
Sorry, I'm shocking with the J's.
I can't remember where I saw that this was on now, but I saw that it was on and I was interested to come as a final year law student. I'm interested in employment law. I'm a union delegate in the workplace as well, so I'm very interested in workplace rights, and I thought this would be a great opportunity to learn some things.
Jared?
Hi everyone, I'm Jared. I work at CEDA with Joseph. I do comms and I'll be filming today, and if you don't want to be on the social medias or anywhere, let me know and I won't put you on there.
Naomi?
My name's Naomi. I also work here at CEDA. Come along to support Joseph because he's full of wealth of information, and I'm looking forward to learning something.
Sorry, I didn't get your name at the back. What's your name?
Oh, Robin, Naomi's support.
Oh, Robert. So, Margaret?
Hi, Joseph. Well, I'm here to learn. I've known Joseph since about 2018, when Joseph and I were first on the Council Access and Inclusion Advisory Committee. So I'm keen to see Joseph show me new stuff that I don't know anything about. So looking forward to it.
Helen?
Hi, I'm Helen. I'm currently at TAFE doing Cert 4 mental health peer work. So back in 2012 I was a health safety rep, but I'd like to learn a little bit more so I can get back out and workforce hopefully next year.
Andrew?
Hi, I'm Andrew. I'm the CEO here at CEDA. I'm here to make sure Joseph doesn't wreck anything.
Sorry!
And to apologise for anything he does wreck.
Or you can borrow Sheepy, it's always available.
Hi, Sheepy. No, I'm also here because I sort of opportunity to listen in on what Joe's put together today, because I know the level of passion that you have for this work and the amount of commitment and effort that you put into it, Joe, is just commendable, and it's really great that people have come along to really, yield the benefits of your big brain.
Thanks. Next slide. I've broken the PowerPoint up in. Do you guys have a copy of the one in sheet, or it's just for me? So I've broken it up into 3 to 4 different areas. So this one, it's just a fundamental understanding on the basis in which the Disability Discrimination Act operates, which is sort of it comes from the United Nations Convention on the Rights of persons with disability, in which it sort of adopts a human rights / social model form of disability. And I noticed that Article 27 on the United Nations Convention of Rights of Persons with Disability solely focuses on the rights of persons with disabilities in the workforce. And I'm just going to read word for word the UNCRPD article. So Article 27 states that it's the right of persons with disabilities to work, crucially, on an equal basis with others. This includes the right to the opportunity to gain a living, but work freely, choosing or accepted in a labour market and work environment that is open, inclusive and accessible to persons with disabilities. Now, so I've got a quick minute-long video that summarises the United Nations Convention on the Rights of Persons with Disabilities. So do you want to click on it and maybe zoom, like make it bigger if you want? Oh, it's a 2-minute video. So, has anybody ever heard of the term nutshell before? It's sort of like a way of just 101, just the basics. Here we go. So, before we delve into direct discrimination and indirect discrimination, it is crucial that as well as meeting these types of discrimination, that they must meet a comparison requirement. So, in other words, that is rather the same conduct and the same circumstances would be considered discriminatory if they didn't have the disability in the first place. So, no, don't play the video yet. As for those who can see on the screen, direct discrimination is explicit. It's also known as less favourable treatment. And a common example of direct discrimination is where a person with a disability is explicitly denied employment because the employer says to them that they're not sure on how to employ a person with a disability. Indirect discrimination is the existence of a rule or policy. So, in human resource management, they have internal policies and rules and procedures where it has a negative effect on people with disabilities. And this is the kicker. The policy or rule must be considered to be unreasonable. And so, and I feel this was subject to a similar court case where it was actually highlighted that it's indirect discrimination if there was a job requirement for a driver's license or to work from the office when the job did not really require to have a driver's license or to work in the office. So therefore indirect discrimination. And do you want to play that video? Now, this video unfortunately isn't captioned properly, so this video I think is a good example of indirect discrimination. So play it if you want. That is a very bad example of indirect discrimination. Has anybody ever experienced examples like that in the workforce? No, okay. So before we go to the next slide and ask a question.
That communication, for example, with the deaf person, if where we can't communicate clearly with the hearing people, and that's not a part of the job, then if that's a requirement they set, and maybe they don't want to train other people, they think it's a waste of time or whatever, that can be a barrier for us.
Yeah. that's, yeah, a bit of an issue, yeah. I'll be happy to talk to you more later about your issues, Billy, if you want. Yeah. Yeah, if you have any other, yeah. So before I go to the next slide, I wanted to note that so you can cover both disability discrimination under the Disability Discrimination Act or the Fair Work Act, which I will go to in the next couple of slides. But it was noted that what was considered to be illegal under the Disability Discrimination Act may also not be illegal under the Fair Work Act. So when it comes to discrimination, it's important to choose whether you want to go to the Australian Human Rights Commission to lodge disability discrimination or whether you want to rely on the Fair Work Act in relation to their own discrimination provision. And I will go in more detail about the Fair Work Act discrimination provision and disability discrimination provisions in the next couple of slides. Does anybody have any other questions on that?
So the indirect discrimination that covers like policy within companies, does this govern like Australian law at all or any other like legislation?
What could you?
I'm thinking like specifically around the wage subsidies that sort of like being would that count as unreasonable, and is that covered by the disability discrimination?
That's a good question. I've never really thought of that. And a funny feeling that I don't think there has been a legal decision in relation to wage subsidies. I think, again, it's more on a case-by-case basis. You know, personally, I'm not a fan of wage subsidies. I'm not open employment, you know, but I understand everyone's different, but yeah.
Sorry.
So what does wage subsidies actually mean? Because this is new to me. Is this like a supplement to, or that someone can, like an organisation gets for employing a person with a disability, or is it the actual person with the disability gets a wage subsidy?
What's your experience, Sean, you know, running a disability employment service provider?
Yeah, so I think from here, I hope I use the right term, but I'm pretty sure the wage subsidy is where someone with a disability can go for employment at an organisation and they do a review, or someone comes in to figure out how much at the percentage of that job they're able to do, and then pay them a wage based on the percentage of the job that they can do, rather than adjusting the job so that they can do it 100%, and sort of paying them less.
In my experience, the way it worked when I was on the board of a very unethical non-for-profit assessors used to come in and do those types of assessments, and it would be very disempowering for the person with a disability. And so what happens is the person with the disability gets paid the same amount as anybody else, but the employer would only need to pay a percentage of the income. So maybe it will be about 40%, maybe it will be 60%. And the government would normally fund the rest of it for a short period of time. And the idea would be to showing employers the benefits of hiring people with disability. But what you find is once the government stops subsidising, then people's contracts will get terminated.
So it's essentially a bit like work experience, but
Yeah, you know, when we talk about lived experience, we're not valuing that as a skill.
Exactly,
We're making it a problem.
So the discrimination lies not in, there's not a financially adverse effect because the person who's being employed receives the same salary as somebody else in the organisation doing similar work.
Yeah.
But the source of the discrimination then is that instead of the organisation making reasonable adjustments, what they're doing is saying, well, we've decided that you can only do this part of the job. Do you think that would get up? That's a tricky one.
It's a tricky one.
On today. Let's go.
Yeah, do you know what? I'll be happy to have a complete talk about this. Because, personally, I'm not a fan of wage subsidies. I think there's a place, especially, you know, if on the DSP you can earn so much, you know, and I have a funny feeling that's why the wage subsidies are used for, because it's like you can only earn so much before the paperwork. But I'm sort of like...
But not everyone's on a DSP.
No, exactly, and I get that. So, yeah, it's a tricky one. I'd really be happy to have a talk to you more about this later. To maybe park a note that maybe that might be a future discussion within the organisation. Talk about wage subsidies and just something to think about for future sessions.
No, it's interesting.
It is interesting topic.
But can I just say something else, and that is that, you know, the problem with, from my perspective, for me the problem with wage subsidies isn't so much that they exist, but rather the way they are used.
Yes, I agree.
So really what you want is to actually provide some supports to employers to make the reasonable adjustments and to employ more people with a disability. But you don't want that to be based on their receipt of government money in the form of a wage subsidy. You simply want that to be perhaps a transition period. I had a conversation with somebody from an employer organisation earlier this year and I asked them, you know, what would it take for small and medium-sized businesses to employ more people with a disability? And basically, the answer was they will ask what's in it for them. And I thought, you know, in terms of changing attitudes, we've got a long way to go if that's their first response. But I guess you can see where something like a wage subsidy fits in with that sort of attitude.
So, I will maybe have to tackle another workshop, maybe early next year to tackle wage subsidy schemes, etc. I'll have to do more research and more intricacies on the legal rationale and the human rights. So, yeah, I'll get back to you on that. Sorry about that, everyone. But that's a great question. Was it you that kicked it off, Sean?
Yeah.
Great question, Sean.
No, this is good to identify.
So, do you mind if we get going because I'm just conscious of timing?
Yeah.
So, as you can see, the Disability Discrimination Act it's you make complaints to the Australian Human Rights Commission. So I don't know if anyone can see. Can everyone see the photo of the difference between equality versus equity down the bottom? And so you see on the left side where everyone has sort of the same supports, and so that's equality, or considered formal equality. And then so equity, or what's considered substantive equality, is where everyone receives the support that they need to be on an equal playing field. So substantive equality, aka also known as equity, is a key principle of the Disability Discrimination Act. It sort of allows, so before I delve into under what grounds of discrimination, it's also important to note the scope of what is considered to be a disability under the Disability Discrimination Act. So, it can be physical. Some of these words may be a bit, in some ways, old-fashioned, because that's just what the Australian Human Rights Commission uses. So it can be physical, it can be intellectual, it can be mental health, mental illnesses. Oh, I must go on the Australian Human Rights Commission says. It can be sensory, so vision impairment, hearing impairment. It can be neurological, so affecting the person's brain, like cerebral palsy, which is my condition. It can be learning. It can include physical, like physical disfigurement, so like scars, amputees, all that sort of stuff. It can also be considered, it can also include immune-related disease, so those who lose immunity and they deteriorate over time. I wouldn't use deteriorate, but you get my drift. So the Discrimination Act makes it illegal to discriminate in relation to disability in specific areas of public life. So that's education, accommodation, public places, goods and services, access to clubs, and employment. But crucially, it also covers sports, but with exceptions. And when I'm not familiar with all the sports exceptions, so if you want to know about disability discrimination in relation to sport, just hit me up another time. I'm pretty sure we've got a sign-in sheet. Maybe if you want to later on, put your email, I'll talk to Kel, we can get some stuff happening.
Definitely.
It's considered an...
There's a question there.
Oh, sorry.
Hi, Joseph. You know how there's a campaign at the moment to have airlines change their policy and allow wheelchair users to stay in their wheelchairs on aeroplanes?
Well, to be fair, I'm a massive fan of that. I didn't know there was such a campaign in Australia, because I know, for me, that's an issue. And
it's a big issue.
Yeah.
And anyway, apparently there is a petition circulating on change.org that I think is about 39,000 signatures. So I'll find that and I'll send it to you.
I would love that.
But I suppose my question is, I don't understand why a wheelchair user hasn't taken an airline to the Human Rights Commission to complain about this.
I've got a feeling that they sort of had ages and ages ago, and I've got a feeling it was part. I try to remember, because I think the I don't know if it was wheelchair use or something else, but and here's the kicker, because the exception to discrimination laws is where it creates an unjustifiable hardship, and so that's the kicker. So that's the defence in relation to discrimination law.
You see, I think that.
I don't know. Yeah.
I think that that the community now would no longer accept that sort of explanation from an airline, because I understand that actually some airlines overseas, all that they do is they take out front seats and set it up so that you can secure a wheelchair in that space.
Yeah.
Now that is not an unjustifiable.
I agree.
In my opinion.
I agree, and you know what? It's funny because did you hear about Delta Airlines? They've done the Delta. Have you heard of Delta Airlines, Naomi?
They're American, aren't they?
Yeah, but so I read an article about a couple of months ago. They're making it like what you were saying, Margaret, standard on all their airplanes commencing next year. That all the new airplanes from next year. They're doing exactly what you said. And to be honest, I was actually going to start leveraging Qantas myself to do that. But since you said there's a petition, send it to me and I'll leverage them, especially in light of Delta Airlines. You know what they're doing.
Well, that's a great idea because Qantas is in so much trouble with their reputation at the moment. They might decide that actually, if they did something really good like this, they'll get some good publicity out of it.
Okay. Just send me that petition, make a note, and I'll reference the Delta Airlines article, and I'll even send that to you if you want, Margaret, for your reference.
Okay.
Well, do you want the?
Sure.
Yeah. Oh, good. So before we so in relation to employment, there is a provision called special measures. So under discrimination laws, it's funny, you're legally allowed to positively discriminate in favour of a person with a disability. So in other words, that means employers must perform a duty, albeit with unjustifiable hardship, to ensure that an employee with a disability has opportunities equal to employees that do not have disability, and allow employers to take action to accommodate those needs of people with disabilities. And employers have obligation to make reasonable adjustment provided that there is not an unjustifiable hardship. And it's up to the employer to determine the unjustifiable hardship. And it's funny enough, that's where I think we have job access. I think they have the Employment Assistance Fund. And I actually wrote that in the Jobs and Skills Summit that, relying on the Employment Assistance Fund and the IS, in theory, you could, what's the excuse for unjustifiable hardship these days? You know what I mean? If it's like financial capacity, then, you've got these support systems in place. And
I suppose, well, actually, that's interesting because for an NDIS participant, presumably part of their plan could include payment for reasonable adjustments at their workplace. Is that, I'm not sure, does anybody know whether the NDIS plans would do that?
So if you went to the NDIS and said, I need a desk for my office at work. The NDIS will say that's a job access
Yep.
problem.
Right.
Now, if you are self-managed, you can do, you can make that decision on your own.
Yes.
And it's something you have a little bit more authority over your
Yep.
funding.
Yep.
But no, if you went directly and said, I need this for work, they will likely say it's a workplace thing.
Yeah. So if you worked from home though, because generally speaking, if you work from home, you have to provide your own
Yes.
office
I
equipment.
was just thinking of this sort of angle on it.
Yeah. So
But you could get tax kickbacks of that, like if you were
But
working for yourself and with an ABN,
yeah.
claiming on tax.
Yes, that's true. But if you were, like so many people work from home now,
yeah, so Kelly said, Jared, you have to work from home. Because everybody's working from home, then it's a workplace thing.
so even in those
But
circumstances,
if I'm working from home because of my disability,
yeah,
then I couldn't. But if everybody's working from home, then
oh, I see. Yeah, okay, that is a very fine distinction, isn't it? Yeah.
Very much.
Does this test it seems pretty subjective. What's unreasonable hardship, doesn't it? I mean, do you have anything to add, anyone practically having seen this in a workplace? I mean, it just seems like it's a fine line, right, for the employer. They're treading very close to discrimination, but then they have this ability to say, oh, it's just an unjustifiable hardship, like they can just write off their responsibility in to them, very simple terms of just saying, oh, it's an unjustifiable hardship, and then that sort of gets them out of their obligations almost.
Well, sorry, there's a lot of onus on the person with a disability to lead the way.
And to come up with
For
ideas
them
and
to come up with
solutions.
ideas.
You know. And if you're someone who's just got into the workplace for the first time, well then you don't know what solutions could work or what can't.
And almost in itself seems like a form of indirect discrimination, because
Exactly.
if you weren't dealing with it in terms of disability, they wouldn't ask someone just generally, oh, how can you, what should you do to sort out yourself in the workplace? But for someone with a disability, then they're going to put that on them and say, oh, you have to sort this out. Like, it's not the same. I don't know. It's just a big circle.
Yeah, and it's funny because the unjustifiable hardship, it's solely up to the employer to go and explain why it's unjustifiable hardship. And then I've got a feeling I do not think that there is a rebuttal process from that flips back to the person with the disability that goes, if that's an unjustifiable hardship, you can rely on Employment Assistance Fund, NDIS, or other forms of support. So I don't think there is that process in place, but I think it will come up, especially because before, when you lodge complaints to the Australian Human Rights Commission, before it goes to court, there's a big focus on resolving disputes between the parties, so between the person, in this case, the disability employer, and they do it in an informal way. So I think in terms of that whole back and forward process, that the person with disability in that process could probably raise, maybe an unjustifiable hardship financially or some other stuff, but employment assistance funds, would that still be considered unjustifiable hardship? And then it would probably be up to the employer to go, yeah, no, and then probably explain why. And then if that doesn't resolve the dispute, then it goes to court. Does that make sense? Yeah. I was conscious time, and so we've got one more slide dedicated to discrimination. So we've covered Disability Discrimination Act. This is pretty much any discrimination and other relevant matters in relation to that's covered under the Fair Work Act. So, as I said, Disability Discrimination Act, which was previously discussed, you lodge complaints to the Australian Human Rights Commission with these, with adverse action, discrimination, temporary absence due to illness, and any bullying, that's covered under the Fair Work Act, and you've got to go to the Fair Work Commission. So do not play the video, I'll tell you when to play. So the Fair Work Act is very limited in terms of its definition of disability, and crucially, there is no explicit form or explicit definition of indirect discrimination. In saying that, the Fair Work Act actually says you can rely on the definitions associated in the Disability Discrimination Act to determine the scope of disability discrimination and whether it's indirect or, but it's more the definition of disability can be the same in both, but they have different aspects of discrimination. So as noted, a crucial aspect under the Fair Work Act is adverse action. So do you want to play roughly the first 30 seconds of the video and make sure it's captioned? Discrimination actually, I think under S351 of the where it says cover discrimination, it actually says an employer cannot take adverse action against certain attributes that people disease. So adverse action and discrimination, you need to know adverse action because adverse action is the discrimination principle under the Fair Work Act. So crucially, on top of the Fair Work Commission, you can rely on the Fair Work Ombudsman in relation to adverse action and dealing with discriminatory conduct in the workplace. And so the beauty of the Fair Work Ombudsman is that it can receive and investigate complaints as well as deal with claims on behalf of an employee or a potential employee. And one of the biggest difference between going with the dealing with complaints under the Fair Work Commission versus the Australian Human Rights Commission is that in relation to discrimination, courts are allowed to issue financial penalties, so fines for those who breach the discrimination and adverse action under the Fair Work Act. But such fines are not available in discrimination law, and so the benefit of relying on the Fair Work Act over the Australian Human Rights Commission is that it actually disincentivises employers to discriminate against people with disabilities because there's a financial risk associated with breaching. Another thing is that it's easier than the Disability Discrimination Act to establish the existence of discrimination because the employee needs only to make an allegation that they were subject to unlawful adverse action before it is up to the employer to question that as to providing a lawful reason why it took such adverse action. And so I've got two key cases that deal with adverse action and discrimination. So it's a New South Wales case, but it was upheld because New South Wales operates, the public sector operates separately to the Fair Work Act. So the Fair Work Act only applies to federal government and private businesses. If you're a New South Wales government employee, you rely on the Industrial Relations Act, which is a completely different requirement. In saying that, the only state in Australia that allows the public sector employees to rely on the Fair Work Act is in Victoria.
The state employees, is that right?
Yeah.
I'm not aware of that. I did know what you said about New South Wales. The state employees here rely on the Industrial Relations Act.
Yeah, and then the Industrial Relations Act, you've got to go to another committee, not the Fair Work Commission. You've got to go to the New South Wales Industrial Relations Committee. I think it's based in Sydney.
Do they have an office here? Do they have a small office just next door to Fair Work, just down on?
I don't know. I'll have to Google that.
Down there?
Maybe I'll have to Google that.
So, the New South Wales Industrial Relations Act, does it include similar provisions to the Fair Work Act?
I think in a lot of ways it's more limited than the Fair Work Act. Because when you study employment law, 99% of the commentary is related to the Fair Work Act, because that covers like 90% of employees, that are public sector employees. I haven't really delved into the Industrial Relations Act. I will be happy to make another mini session down the track to cover what's under for New South Wales public sector employees, if that's something you would be...
Yeah, because it just sounds like New South Wales public servants are worse off than every other employee in this state, just because they're not covered by the Fair Work Act.
Yeah, that's very...
So does that mean that the Fair Work Act, none of its provisions apply to New South Wales state public service employees?
I have a funny feeling that may be the case, yes. And so if that wasn't helpful, I know because technically councils are under the New South Wales public sector, aren't they?
Yeah.
That's right. So although elected councillors, we're in a category all of our own.
Okay. So, yeah.
Yeah, separate to the staff.
Yes.
Like the staff are on the state.
Yeah.
I didn't know that.
Yeah, I just don't know where we fall, really.
Yeah. So I hope this somewhat illuminated you to the divisions between state and federal, legislation. So, because the state government has a separate Anti-Discrimination Act. So on top of that, federally you've got the Dispute Discrimination Act, you've got the Anti-Discrimination Act, you've got the Racial Discrimination Act, and you've got the Sex Discrimination Act. The state government has a separate discrimination act, and when you raise disability discrimination, I think you can rely on both federal and state, but I think that 99% of people rely on the federal one because it's more broader. I think the state ones, as like with industrial relations, I think it's a bit more limited. I may have to do another session highlighting not only the employment rights in the public sector, but also the state government, the Discrimination Act under state law in New South Wales as opposed to federal law. I just thought to encompass like the majority of, employees, in
where
the
most of the action is.
Yeah, this is broader. This is like a broad overview sort of thing.
that's
It would be
right.
worth revisiting, particularly with New South Wales Health employing so many people. Might be worth doing a special revisit your rights at work, state employees edition.
Yeah. So Joseph, you mentioned a little while ago that there were a couple of cases about adverse action.
Yes.
Because I actually don't understand what that means, adverse action.
Well, adverse action is sort of, it's a tricky one, because adverse action, it's sort of where employers take action that has a significantly negative repercussion. And so this case I'm going to mention, it's a New South Wales case that was covered under New South Wales employment law, but it's now applied federally under discrimination provision in the Fair Work Act. And crucially, this will be a good one for a lot of people with disabilities. Employees are not required to disclose any disability to prospective employers where they reasonably believe that the disability will not impact or be relevant to their performance in the job role. So it's like, say you apply for a job and you've had so many years experience, you could do similar performance, and you've researched the organisation, the equal opportunity employer, etc. And you don't need reasonable adjustment, then there's no requirements to disclose your disability. Do you have a question, Naomi, on that?
I'm connecting with this very much because I've actually experienced it personally. I was in my third year doing my clinical placement at Centrelink, and was at the call centre there. And my job was I was working with the social work team there, so I was studying social work. And basically, the lady who was my supervisor, because of my disability being so physical and visual, she asked me what would you need to be able to do your job independently, and I told them all then, but little did I know, once I was a week into the job, and I started talking to a few other employees, and they told me that my supervisor sent an email around to the whole call centre letting them know that she was having a student doing a clinical placement and that she has disabilities X, Y and Z.
Wow.
So that, for me, I was already, and they wouldn't know what my diagnosis was, and they didn't need to know. I gave her too much information, but I was a student, and
you didn't know any better.
I didn't know any better, exactly, Joe. And so I started to think, they all knew everything about me before I even walked through the door. And then it just kind of snowballed, and it really started to affect my mental health as well. And, it was a shitty situation. And the university wasn't supportive in me because I wanted to get this addressed and dealt with. But the social work department at the uni, all they could think about was, we'll lose Centrelink as a potential placement for future students. That was back this happened back in 2004. And it's
so do you mind if I keep going? Because we've got about one more court case and about 2 more things to discuss before a question and a lunch break. I have a funny feeling Mel was meant to...
Yeah, it's just been a bit of a hold up with the lunch.
Yeah, okay. So we'll have time, I think, to go through it and then have lunch break, if that's okay with everyone. So we'll talk about the Fair Work Act and adverse action. So what under the Discrimination Act can provide protection for both employees and potential employees, provided that it coincides with the adverse action under the Fair Work Act. And so a key exception, so this is the exception to the rule in relation to discrimination and adverse action. There is a defence for employers of failing to meet the inherent key requirements of the role in which the employer cannot make reasonable adjustments to ensure that the requirements of the role are met. So I think, when you think of reasonable adjustments, productivity, you think of employment assistance fund, you think of NDA, so that sort of kicks back to the unjustifiable hardship and, that whole discussion we had about, the process and what is unjustifiable hardship and the Discrimination Act. In the Fair Work Act, it's inherent requirements. So it's not. Don't play the video. There's no more video. So we talked about adverse action and discrimination. This is another good one. Temporary absence due to illness. So I know as a person with a disability, you might have emergency hospital trips in which, you'll be absent from work. And so an employer must not dismiss an employee because the employee was temporarily absent from work due to illness or medical or injury. So, but in order for this to happen, the employee needs to provide a medical certificate within 24 hours of the absence or reasonable periods, to the employer. So, say that, you don't know, you might be off for 4 days, but you don't think, it's not only 24 hours, but a reasonable period. So if you work casually and you work Mondays, Tuesday, and you get sick on Wednesday, and you have to probably let the employee know by Friday, you know what I mean? Because you usually work Mondays, Tuesdays. Do you get what I mean? So it's another reasonable period. But the general rule is 24 hours if you know you're going to be sick. There is an exception to an employee not being able to dismiss an employee. So an employer is allowed to dismiss an employee where the employee's absence from work is either more than 3 months or there were 3 months worth of absences in a 12-month period. And this has to be met as well as those absent periods, that they are not on forms of leave. So personal leave, paid leave, we will discuss relevant forms of leave later. Any bullying is another provision.
So, are you saying that it's 3 months on top of leave?
Yes, so 3 months on top of paid leave or unpaid leave, and we'll go through that later. So, so it's 3 months on top of leave, not 3 months inclusive of leave. So, does that make sense, everyone? So, one last thing before we do the interactive question. I've got a bunch of questions for you, but one last thing. So, anti-bullying is another provision under the Fair Work Act. So, it's where either a person or multiple people repeatedly behave in an unreasonable manner towards a worker, an employee, or multiple employees, and that the behaviour being done created a risk to the health and safety of the employee. So it's funny, some examples of bullying is being excluded from work-related events. So that's an example of any bullying being excluded from work-related events. You may think it's not a risk to health and safety, but in a way it is, because that sense of social connection, sense of belonging in the workplace. Another example is belittling or humiliating offensive comments. There are exceptions to the anti-bullying provision. So it does not include actions that are like performance management that is done in a reasonable manner. So this includes disciplinary action for misconduct, informing workers about unsatisfactory work performance or inappropriate behaviour at work. So those stuff are not considered bullying, informing workers about, dissatisfaction with performance. I just think it's how you go about it. So then, does anybody have any questions on that before we go to the interactive question that I'd love for you to discuss among yourselves?
I think we're good.
Nothing, Margaret, about adverse action, etc.? Is it still over your head?
Not at this stage.
Okay, so interactive question. So has everybody had a quick discussion on that discrimination question? So I'd like to go over, would everyone be able to put their hand up if which one of you think it's discrimination if it's the first one?
Depends.
The second one?
Well, when I first read the second one, I took that to be the actual the applying part for a job, as in, is there other alternative ways that you can apply for the job as opposed just to being, like how to, maybe the interview process needs to be a bit different.
Okay. And how many of you think it's the third one?
Oh yeah, definitely the third.
So you are absolutely right, it's the third one. So let me go through those 3 examples and I'll explain why it is or isn't. But with the third, I'll let you decide why you think it is discrimination, if that's okay. So the first one, we've got the unjustifiable hardship defence. So I think you are right in that it is a maybe, but inadequate resourcing, it's usually an unjustifiable hardship defence, So I think it depends on, I agree it's a maybe, it depends on, whether they could leverage NDIS, Employment Assistance Fund, etc. But the general rule is that inadequate resources, it's an unjustifiable hardship if employers can't get the resources.
Yeah, but I suppose there would be some situations where really inadequate resourcing doesn't amount to a proper defence.
I agree.
It's the employer really isn't sort of making much of an effort to sort it out.
Yeah.
So
I agree, and to be fair, it's a case-by-case basis. That's partly why we have lawyers, because every situation is slightly different. There's no situation that's 100% the same. So that's why I get where you're coming from. Is that right, Margaret?
Yeah.
So the second one, did you hear me talk about positive discrimination and special measures in which it's actually allowed for employers to positively discriminate in favour of people with disabilities, and that's where the alternative employment measures come into play, because you're creating a different system that has potentially a positive impact. So, does anybody want to hit me up with the third one as to why it is discrimination?
So it's a reasonable adjustment?
Keep going. It's... Naomi, you were going to say something?
Well, I just think if it's, if everyone had been working from home, like if the person has their house already geared up and set up to work from home, then why can't they continue to do that? That's my opinion. But
you heard my analogy in direct discrimination with the driver's license. If the job does not require a driver's license to perform the role, then, and that's still, it's still in the job description, you must have a driver's license, but you don't need to perform the role. Indirect discrimination. That same thing applies there, because it's like you're meeting the requirements of the job, the policy, and thing. It's sort of unreasonable if you've previously worked from home and it's worked, and now the employers say all employees must go back to the office. I have a funny feeling there was a recent court case. I actually don't know if they challenged that or if it upheld that. It was something I read recently, and I think it may have upheld that example. So I'll have to. I read it probably about a week ago, and I was going to reference it in my notes, but it didn't save, so I'll have to, yeah. But that's where I got that example from. So, I was going to stop there and have lunch because the next slide is the longest content heavy. So I just thought recuperate, mingle. I know we're here to 1 because based on the content, I've got 1, 2, 3. I've got about less than probably about 50% left. So, yeah. I don't know if you want to mingle, wait for lunch, or keep going. Are you feeling energetic enough to go through the most content heavy, or do you want to wait for lunch?
I can keep going.
Yeah, I just have to get a bus at 1:10 so I've got to be out of here, across that road.
You want to keep going, Naomi?
Sure.
You want to keep going, Margaret?
Yeah, I'm fine.
Helen, keep going. Jared, keep going.
Wherever you want, man.
Jake.
Consensus, yes.
Yeah. Well, how about we just get to the National Employment Standards? So, these National Employment Standards, anybody familiar with them? Can everyone read that, or does someone want to read it? Put your hands up if you're familiar with the National Employment Standards. Okay, great. One person. So, you may be willing to flesh this out with me, Jake, if you want to flesh this out in the further. This is just an overview that I've got prepared.
I'm confident that you're gonna have it.
Pardon?
I'm confident that you're gonna cover it.
Okay, thanks. Because I've got my notes here. So, as I said, under the Fair Work previously, the coverage of Fair Work Act in New South Wales is limited to private businesses, and we were discussing about the New South Wales public sector. So, first National Employment Standards, we have maximum weekly hours, which is, there's a general rule, 38 hours, but I don't know if anyone's ever heard of the new phenomenon, the 4-day working week. Has anyone ever heard of that phenomenon? Yeah. So I've got a feeling that potentially, because the Jobs and Skills Summit paper is coming out on Monday, I was going to talk about it today, but I may have to do a follow-up session because I was going to talk about some findings from the Jobs and Skills Summit, which talks about the future of employment law. But I just read an article yesterday that it's going to be released on Monday, and I was hoping it'd be released before today, because today's the last day of the canvassing, and just thought, but may have to discuss that another time.
On your podcast.
So the general consensus full-time hours, it's still the 5-day, 38-hour, may change depending on what comes out Monday. I'll keep you in the loop of that. So you may also be required to work additional hours on top of that 38 hours, provided that it is reasonable to do so. And so you often hear that lawyers and doctors, they go beyond the 38-hour week, it stretches to 40, 50, 60. That's legal for them because it's sort of reasonable. And so that reasonable factors, some of these factors include the nature of the job, so the industry you work in. So if you work in the legal industry, you may have you may be required to work more than 38. The role, you've got the risk to the health and safety of the employee, as well as providing relevant notice, the employer providing relevant notice to the employee that I'll need you to work more than 38 hours. Does that sound about right, Jake, for that?
I'll leave it to you. I think you're headed the right way. I'm just going to let you keep doing what you're doing up there.
Joseph, I've just got a question. That list of factors that are taken into account to work out whether a request is reasonable, does it include caring responsibilities?
Potentially, because it's a risk to the employee's health and well-being. So, you know what I mean?
Yeah.
It's like, I'll have to have a look at the list of factors, but they're not limited factors. You're not isolated to a certain, list. It's just, they're just like the most common factors.
Yeah, it's not an exclusive list.
But then, to be honest, this might be the next one for you because flexible working arrangements. Have anyone ever heard of flexible working arrangements?
No.
Is that a little bit like when you're on call?
Call?
Is that more like flexible when you're on call for work?
No, I don't think so.
I thought it was about, having, being able to work periods of time from home, being able to change your working hours.
Yeah, that sort of stuff. Yeah. And but crucially, flexible working arrangements, as a general rule, only applies to employees that are not casual employees and that have worked for at least 12 months. The employee must either have a disability, parenting or carers responsibilities, or experiencing family or domestic violence. Casual employees, that there is a caveat, so there is an exception in which casual employees are entitled to flexible working arrangements. I think it's a relatively new provision, and that they can only request flexible working arrangements if they have worked for the employer for at least 12 months and are working on consistent and regular shifts. So, say I'm a casual employee, I know I'm generally only working Mondays and Tuesdays, and that after that 12-month period, there is expectation of ongoing work. It's also crucial that for casual employees, there must be ongoing work after the 12-month period as well. So, say, if within the context of CEDA, if you're a casual employee and you work regular days and you've been here for 12 months and you know that, at least 12 months, and you know that you'll be working ongoing, you're entitled to request a flexible working arrangement. So, some examples of flexible working arrangements, we were talking about change of hours, working from home, other ones. So it can also include job sharing. So say, for example, if the role you were working in was 38 hours, And you can only functionally do 25, 26 hours. You can request flexible working arrangement, maybe partner with somebody, work those 24, 26 hours, and know someone can cover the remaining 12 hours for the equivalent full-time more. Now, so in order to, were you having a question, Amy? Did you also, so in order to request a flexible working arrangement, it has to be in writing. It has to address the changes you want and why you want those changes. And the employer has to respond to the request within 21 days of receiving it. And the request, the response from the employer has to be in writing. So there are exceptions to refusing the request there are exceptions to flexible working arrangements in which the employer can refuse to accommodate flexible working arrangements. So all these requirements must be met. The following requirements must be met. The request was discussed. They genuinely attempted to reach an agreement between the employee and employer. They met the criteria, but so all of these following have to be met in order to refuse a flexible working arrangement. So the employee and employer has not reached an agreement. The employer has taken into consideration the consequences of refusing the flexible working arrangement, and this is the most important one. There are reasonable business grounds to refuse the flexible working arrangement. This is not limited to proposed alternative working arrangements being too expensive for the employer. There is no capacity, or it is considered impractical for the employer to change the working arrangements of other employees to accommodate the request, and the proposed working arrangements are likely to result in significantly loss to efficiency or productivity, as well as either having a significant negative impact on customer service. So, do you mind if we finish off the flexible working arrangement and then have a lunch break? Because I just saw Mel coming and we can continue after that. So, now, if an employer denies a flexible working arrangement request, it must be in writing and provide details of the reasons why it was denied. So that is where the reasonable business grounds for denying the request apply. So yeah, I think Mel and Kelly's getting lunch set up if you want to mingle. Yeah, we've got about 1, 2, 3, 4, 5 more likes, and then one question. Then we've got unfair dismissal. When is it illegal to dismiss an employee? And a summary of other relevant recent changes to employment law in the past year and a half. And then, that's pretty much the agenda for the rest of the day.
Nice, okay.
Just to clarify, we recap 2 of the National Employment Standards, the maximum weekly hours and the flexible working arrangement. So, how I previously mentioned how with the, I think, flexible working arrangement, there was an exception for casual employees in which that, they had to be working ongoing, minimum 12 hours, regular shifts. I think that was because there was a court case which defined casual employment. And so this next thing, a request for casual employees to become permanent employees follows on that. So the scope of casual employment is so they have to have at least worked for employees for at least 12 months. But mind you, a lot, not all, but dare I say a few, especially in relation to casual employment, of the small businesses with less than 15 employees have separate sort of rules. And so this casual conversion, and I think in some cases flexible working arrangement, and I've got a feeling it might have been pay and notice of termination. I think they're the exceptions under the small business rules, and we'll also cover that when we get to unfair dismissal. But so casual employees work for an employer for at least 12 months. They have worked regular hours on an ongoing basis for the previous 6 months and are expected to work an equivalent part-such full-time basis without significant change. So if you meet those criteria, the general rule is you can request to become a permanent employee. As with everything in employment, I keep saying there are exceptions. Casual conversion, no stranger to exceptions. So you can refuse casual conversion on reasonable grounds that is not limited to the following: within a 12-month period, that the employee's role would no longer exist, the employee's hours of work would be significantly reduced, or the employee's days or hours of work will significantly change and cannot be accommodated with the times that they would be available for work. So and I think casual conversion has to be done in writing. So there are multiple types of annual and paid. So now we're up to annual and paid leave. There are multiple types. So pretty much all of the paid leaves, with the exception of family and domestic violence leave, only applies to permanent employees. Casual employees, the only type of paid leave they're entitled to is family and domestic violence leave, and that's a new recent development. And so the leave for permanent employees, or the types of leave accumulate. So say you're entitled to, say for example, you're entitled to 4 weeks of paid annual leave for permanent full-time workers. You've only used up 2 weeks. That means the following year you could get 6 weeks because you've used up 2 weeks. You get 4 weeks every year. So next year you not only get the 4 weeks, you get the 2 weeks of leave you haven't used the previous year. And I think you have to stay within the same job for the leave to accumulate. Is that right? Or are you nodding your head as in no, or nodding your head as you don't know?
I don't know.
Jake?
Do you mean with the same employer?
Yeah, with the same employer for the leave to accumulate.
I'm not sure. I would think you would have to stay with the same employer for the leave to. If you leave your employer, would your leave would reset, wouldn't it?
Yeah, that's what I think.
You stay with the same employer, but change jobs.
Yeah.
Your leave wouldn't carry over.
Yeah.
And in some circumstances.
Yeah, the same organisation. If it's a different position,
Yeah.
Yes,
yeah, but if you change to a different organisation, unfortunately, you just lose it, or you have to start all over again.
yeah.
Sounds right.
Yeah, that's correct.
In some circumstances, depending on what leave you have built up, they might pay you out when you leave.
Yes, your annual leave balances, especially. Typically not personal.
So how is annual leave different from paid?
So I was talking about annual leave. Yeah, I was just using that.
Sorry, okay, yeah.
Like I was just using that as an example.
Right, okay.
Of like accumulation. So annual leave, full-time, part-time employees get 4 weeks of paid leave or the equivalent of 4 weeks. I think paid leave if you're part-time, based on the ordinary hours of work. So if you're considered a shift worker, so a shift worker is different from a casual employee, isn't it? Do you want to explain the difference between a...
No, I think you got it. Okay, I want to let you just keep going. You got good momentum going.
To be fair, because in my notes, I haven't put the definition of shift worker. So if you want to hit me up with the definition of shift worker, come to me later or ask questions and I'll quickly Google it. Shift workers are entitled to an extra week of annual leave. So that makes it 5 weeks for shift workers. Crucially, employees are not entitled to receive paid annual leave on days that are public holidays. So they're the only days, and I think even weekends, because weekends it's outside the normal hours, so you can't get paid leave for weekends.
That's a good question. If it makes up your ordinary hours, though, then it would contribute to your annual leave.
Yeah, I agree. But most people don't generally work on weekends. So, but...
Shift workers do.
Yeah, you're right, care workers. So in that case, if they work permanent on weekends, then, yeah, they're entitled to leave based on the hours of work. There's personal/carers leave, which in some cases it's also known as sick leave. So there are 2 types. You can get paid and unpaid. So a casual employee, as discussed, with the exception of family and domestic violence leave, they're only entitled to unpaid leave. So permanent employees get paid sick leave that's based on their ordinary hours of work and can be accumulated every year. So full-time employees get 10 days paid a year. Part-time employees get 1/26 of the ordinary hours of work in a year. So it's very mathematical for part-time employees, unfortunately. So you'd have to look at the contract and go, you're doing like 20 hours a week, 20 times, and you're working like 40 hours a week, 20 times 40, you know what I mean? Yeah. So unpaid sick leave, it's 2 days per occasion. So 2 days unpaid sick leave for every time you were sick. So I don't think you can be sick for, or you may be able to stretch the unpaid leave, but that sort of touches in the temporary absences due to illness. So there is another thing called compassionate leave. So that's where immediate family or someone in the employee's immediate family or household has either personal sickness or injury that poses a serious threat to their life, or has a stillborn baby or miscarriage. So I think an perfect example would be family member would have cancer, just being diagnosed with cancer. So they would get 2 days, permanent employees would get 2 days paid leave per compassionate reason.
I think it also covers if a family member or someone as close who's passed away.
Yes.
They cover that as well.
Yes, I think that's right too. So there's family and domestic violence leave. So recent changes have made. So to be eligible, it's good. The family domestic violence has to occur outside of normal working hours. So you're working 9 to 5, but the issue of family domestic violence happens at 8 o'clock at night. So the family domestic violence is considered violence that is violent, threatening, or abusive behaviour by a close relative member living in the same household as the employer, or the employee's current or former partner who seek to coerce or control them and causes them to be fearful or suffer harm. So in those situations, both casual and permanent employees are entitled to 10 days per year. I don't think that.
So I was just wondering, do you know what the requirement is to unfortunately prove that you need that leave? Do you need a police report or a doctor's report?
That's a good question. I haven't really looked that up.
I was wondering that myself.
You probably would need to have like a police incident because they would actually come and attend. So they would probably give you police incident.
That's a good question. Do you mind if make a note of that, and because I'm just conscious of time, and so I'm just gonna go through the content, and then if anyone wants to stick around 5-10 minutes, we can address those.
Billy said, I'm not sure about maybe even just physical evidence, even the person that has clearly had abuse. I mean, wouldn't that be physical evidence enough?
But abuse cannot, it's not just physical, it can also be emotional.
Yeah, I'll let you research the nitty gritty, but yeah, I was just spitballing, sorry, yeah.
Yeah, all good.
From a legal perspective, I guess, yeah.
Yeah. So there's also considered community service leave, which the most common community service leave is jury service.
Volunteer fire brigade, or
Yeah.
I think the
SES.
yeah, SES,
Yeah.
or reserve.
Which you can get jury duty if you have a disability.
Yeah. And I actually had in my notes that it was paid leave. I think it's paid leave, isn't it, for permanent employees?
Not too sure on that one, sorry.
If you get put on a jury, I was on a jury once, and we actually got paid transport costs plus the time we were there.
Yeah,
And you have to declare it through Centrelink, because I went in and they said, no, don't need to declare it.
Okay.
They give you 2 days, in the NES, is it 2 days paid for community leave? I'm not sure about jury duty is a separate thing, but like if you're a fiery, if you do RFS, that sort of stuff.
Yeah,
I believe there might be some unpaid entitlement attached to that as well.
Yeah, I'm just trying to
Or
pay.
the 2 paid days, but then like, say if there's a massive bushfire on, you get this, it's like a reasonable,
Yeah,
to go in.
yeah, because with the exception of jury duty, community service leave is unpaid. So jury duty is the only, yeah. Yeah. Employees, with the exception of casuals, are entitled to make up pay for the first 10 days they are absent for jury duty. So I think that in some ways that means the first 10 days of jury duty they're entitled to paid leave. I think after that it's unpaid.
Yeah, wow.
That's from...
I don't know. I've never been called to jury duty.
Pardon?
I've never been called to jury duty in Australia.
I have twice.
Got once, I showed up late.
So there's 2 other leaves I was going to touch. There's long service leave. Now, interestingly, long service leave is one of the only... So long service leave, and I think... Yeah, it's one of the only leaves that it's not covered under the Fair Work Act. It's a state-based leave. So, in New South Wales, long service leave, it's actually under not the federal government, the New South Wales government, and it's minimum of 10 years of working for the employer. You are entitled to 2 months' pay at ordinary wage, but you are also entitled to a pro rata or like a equivalent basis if after 5 years the employee resigns due to illnesses, incapacity, or other, necessities that they can't do the job after 5 years. I don't know if that's with WHS. I'm only just going by what I've read online. I had these notes stashed and I rechecked and all that stuff.
Craig, it's in the follow-up email. Your rights at work follow-up email to the people who attended.
Yeah.
So then there's parental leave. Everybody familiar with parental leave? Yeah. So have to work for an employer for at least 12 months can be it can be paid or unpaid. Paid at 20 weeks of national minimum wage. It's done through Centrelink. Employers can also offer paid parental leave, and you can actually do dual Centrelink and dual employer paid parental leave. You're nodding your head, so did that happen to your partner?
No, I was trying to set it, like I wanted to sort of set it up with an employee that I had, but she hadn't been working for me for longer than 12 months, so I wasn't able to do it through Centrelink anyway.
Yeah. So then, you can also do unpaid leave, which is up to 12 months. But it can also be extended. I think it's up to the negotiation between employee and employer. Public holiday works, permanent employees are paid normal wages for day off so if the permanent employee normally works on a day, that is a public holiday. They get normal pay. They can refuse to work if they are asked to work, but it has to be reasonable to refuse work. So termination notice, permanent employees. So termination notice, it's subject to the award. So every award for permanent employees has different termination notices. Notices can be paid out instead of working during the notice period. Casual employees do not have to receive notice, so you can be dismissed at any time as a casual employee. I'll just quickly say yes, no, if that's okay. So, casual employees are entitled to paid leave. That's family and domestic violence leave. Employees are allowed to work more than 38 hours a week, provided it's reasonable. Casual employees cannot request a flexible working arrangement unless they meet the requirements for casual conversion. Next slide. So we've got unfair dismissal. It only applies to permanent employees who have worked for the employer for at least 6 months. And if it is a small business that they hire fewer than 15 employees, then it's 12 months. So you have to have at least work 6 months for if you have more than 15 employees, or 12 months if you have less than 15 employees. So unfair dismissal. It is unfair dismissal if you exercise any of your rights under the National Employment Standards that was discussed previously, and you were dismissed for those national, for raising your rights under those standards. So there is an exception to unfair dismissal. It occurs when there is a matter of genuine redundancy. So that means the employer no longer requires the job to be performed by anybody in the organisation, and the employer has obliged with, the award, enterprise agreement, contract. It's funny, it can still be considered genuine redundancy if some of the duties being performed by other employees who are not made redundant. So, say for example, a perfect example would be a dedicated role, and that role is no longer needed, but some of the functions of the role are spread over 3 or 4 other people working within the organisation. That can still be a matter of genuine redundancy because the role itself is not really needed, but some aspects of the role can be spread to other people. So that's an exception to unjustifiable hardship. So unfair dismissal has to be harsh, unjust, or unreasonable. It can either be one of them or all 3 factors. It depends whether there was a valid reason for the employee's dismissal, which includes, not limited to, whether they were failing to comply with the inherent key requirements for the job, whether there was a substantial and deliberate breach of company policy, or whether there was sufficient evidence for the loss of trust and confidence in the employee. Another thing to take into consideration is whether they were given procedural fairness. So that means whether they were being notified of the reason for the dismissal, as well as them being given an opportunity to respond for the reason of the dismissal. So when it comes to that, the employee has to be given enough notice and enough detail to understand the allegations. Dismissal can also happen in relation to workplace performance, in which they must have been warned about unsatisfactory work performance in the past, and rather they've been given an opportunity to improve. Yeah. I have more content about unfair dismissal, but other facts, I'm just conscious of timing, I can go through it, but I just want to also go through the recent changes to employment law as well. So, misconduct in relation to unfair dismissal is the unequal treatment of employees, and the personal matters of employees. So there are other factors to take into consideration when it comes to unfair dismissal. We have any other questions about unfair dismissal? So last slide. Second last slide. I was going to do a question. So, which follows unfair dismissal? It's actually the second one, because it's a breach of national employment standards in relation to the right to paid leave. So yeah. And the second one for those is taking entitled sick leave, where an employer does not like this and decides to dismiss you prior to taking the leave. Next slide. So, a big focus on the recent changes to the Fair Work Act is a focus on gender equity and gender equality as a result of the Royal Commission in relation to the Respect at Work report that dealt with sexual harassment and sexual assault at work. There were the existence of expert panels in which will focus on low pay and conditions in female-dominated industries. So, for example, the care support sector could actually make it easier for the Fair Work Commission to issue orders to increase pay in that sector. Implementing the recommendations of the Respect at Work report. So it prohibits sexual harassment in relation to the Fair Work Act. It creates a positive, so it makes employers have a duty to prevent sexual harassment in the workplace. Another thing interesting, it makes it a workplace right to discuss remuneration, to discuss pay or mention pay with other people, because previously adverse action could be taken against employees who discussed pay, but not anymore. So you're now legally allowed to discuss pay, because most of the time before that it was like a term and condition in the contract. You're not allowed to discuss, how much you earn. It's all confidential, private. But now they've made it that you're allowed to discuss with others how much you get. You didn't know that, Sean?
I had no idea. I thought that was just you were able to do that.
No.
No matter what. I didn't realise it was only a recent thing.
Yeah.
I wonder if that was because the Lisa Wilkins thing, where she didn't realise that Carl Stepanovic was on 4 times the amount of money as she was, and so when everyone found out, it was quite a big deal.
Yeah.
So I'm wondering maybe that's one of the recommendations.
I'm glad now it is alright.
Yeah. So last recent change, no, go back. Last recent change, it's not in the Fair Work Act, but it was also covered as part of the other employment law changes. It allowed the Australian Human Rights Commission to have the power to issue inquiry into systemic workforce discrimination. So, say there is an employer who has, a history of systemic workforce discrimination, disability, sex, etc. So, in the context, systemic unlawful workplace discrimination is unlawful discrimination that is against, those like age, disability, race, sex, that is continuous or repetitive. So it's not just a one-off, it has to be ongoing. It has the powers to do so when it desires. And that's a new recent change. And I was gonna talk about the Jobs and Skills Summit finding, but that won't get released till Monday, so that might be another follow-up session in which we discuss the findings and maybe talking about using collective power to leverage politicians to incorporate those findings in the legislation. So thank you for coming, and I hope you learnt heaps and would love to mingle, and if you Yeah.